Hello, everybody. Good morning from Brazil to our distinguished panelists. I have the pleasure to open this panel today. We have the presence of Edurne Navarro from Uria Menéndez and Daniel Bitton from Axinn, moderators Ricardo Motta and Silvia Fagá, who co-heads the digital markets group of IBRAC. Will conduct this conversation and will properly introduce our guests today. But I want to say on behalf of IBRAC that we are very happy with your presence today. And I'm sure that the contents of this conversation will be very helpful for practitioners in Brazil, both economists and lawyers, the associates of IBRAC as a whole. And I want to ask if Bruno Drago wants to say welcome notes.
No, I think you've done already. Again, thanks Daniel and Edurne for blessing us with their words about the US and Europe. Thanks a lot.
So Ricardo and Silvia, the floor is yours.
Thank you, Guilherme. Thank you, Bruno. First of all, hi, good morning, everyone. It's a pleasure to have you here. First of all, such qualified audience, as always. And I would like to thank especially Daniel and Edurne for accepting our invitation to speak here today. Thanks for coming. Edurne, I was telling the group before in our meeting that Edurne is five hours ahead and Daniel is 5 hours behind. So I think that we are actually covering a significant time zone lapse here today, mostly all the Europe, South America, and North America as well. So, but thank you for accepting, for bringing us some clarifications about these issues that we'll be discussing today. But just before formally introducing our guests, I'd like to say hello to Silvia, who will be moderating this panel with me. I would like also to thank IBRAC, Bruno, Guilherme, Ricardo for all the supports and for encouraging us in all activities developed by the Digital Markets Coordination. So thank you very much. Thank you for supporting this event as well. And said that, I would like to quickly introduce our speakers. Some of them are, I think both of them, in fact, they are pretty much well known here in Brazil. So first, I have here Edurne Varona. She's partner of Uria Menéndez and is currently in charge of managing the firm's Brussels office. Edurne has over 25 years of experience advising Spanish, European, North American, and Asian undertakings in several different sectors. Thank you for coming, Edurne. We also have here Daniel Bitton. He's partner of Axinn. He's based in San Francisco and he represents clients in several different industries and is currently deeply involved in several different investigations on tech and digital markets. So they are pretty specialized in these issues and we are pretty thankful for having you here today. So we've prepared this panel in the format of questions and answers. And the idea is to have something really dynamic with the speakers and with the audience. So please, everybody, feel free to make comments or even to raise your hand and make questions for the panelists. I think the idea is to have this very light conversation and have clarifications on their experience outside Brazil. So to start with a very beginning question, I would like to start, first of all, with you, Edurne. And again, thank you for coming. But we have followed in the last years several different investigations initiated by the European Commission and also others by the European national authorities against different tech companies. So we have seen against Facebook, Google, Amazon, and very different companies and others, Apple as well. Some of these investigations are included in the Court of Justice because they have started since the beginning of the 2000 years. Some of them are still before the European Commission. So we have different stages among these different investigations. I think, first of all, is it possible to map those investigations? What are, in fact, the most relevant cases that we have now going under the European system, if I could call that way. What's your perspective in these investigations? And what do you think are the most emblematic cases that should be rolled, or at least we should hear some repercussions coming from the authorities over the next year, or at least until the end of 2022? What's your perspective as a whole?
Thank you very much, Ricardo, and thank you to all the organizers of this event for having me here. And indeed, as you have mentioned, in Europe, there's a lot of attention driven to all the digital and larger companies in that sector which are at stake. There are ongoing procedures. There have been some which are at least already having had some steps. And I will mention, for example, the Google shopping case, in relation to which last November we had a first ruling from the Court of Justice in Luxembourg, the European Court, which has had a lot of attention. And now we have the appeal pending before the Court of Justice, but that will take another couple of years still. There are also cases before the Court of Justice which are pending, for example, in relation to Facebook, which is the case, the result of sanctions imposed by the German competition authorities in relation to access to data, which were considered abusive. And that has led to a preliminary ruling, which will have to be sorted out by the Court of Justice. And we also have ongoing cases before the European Commission. And there I will note two. First of all, against Amazon in relation to preferencing, and the fact that Amazon is at the same time a platform where other players and operators place their goods. But at the same time, we see increasingly that Amazon is also selling its own products, which compete with the ones which are being put on the platform by third parties. And the big question there is what type of information flows within the two units of Amazon, the ones which serve third parties and the ones which favor their own products, and what Chinese walls in relation to information, etc., can be at stake, and the Commission is analyzing that. And then also in relation to Apple Pay, there have been a lot of complaints from various different players and operators in Europe, and we have been acting for some in all sort of sectors where the issue is the access to the App Store of Apple Pay and under which conditions that is being granted, etc. So those, I think, are the two main cases pending before the European Commission. But we also have the national competition authorities, which are increasingly active in this sector. And there I will just note that the Dutch Competition Authority, which has been particularly proactive and which has had several recent cases in relation to dating apps, and where both Google but also Apple have been the subject of investigation, some commitments already offered, and that is still an ongoing saga as well.
Okay, thank you, Sil. I think you can make the next one.
Yeah, then, well, let's say same question to you, similar question to you. More recently, you have seen new investigations, lawsuits against big tech companies in the US. Some of them are just beginning, but with a lot of repercussion in the media. So how do you view these movements? What are the most relevant cases? Are they close to the cases relating in Europe? Do they have the same kind of claim or same kind of theory of harm? What do you think about that?
Thank you, Silvia, and thanks everyone for having me. It's really a pleasure to be speaking with you about these issues that I work on much of my life these days. So, and with that, I'll just make the usual disclaimer. I often can't help but give opinions. I'm going to try to just sort of be mostly descriptive, but to the extent I express opinions, they're my own and not my clients or my firms. But yeah, there's as is the case in Europe, and by the way, Edurne, it's great to see you again. A pleasure to be on this panel with you. There are a lot of similar investigations or litigations going on, as Edurne mentioned, in I do love the call out of the Dutch Competition Authority by Edurne, because that's where I was born and raised, and I just love it that even in pandemic times, the Dutch are really worried about making sure we can date each other effectively online. So in just what I'll do is try to give a quick overview of some of the big cases that are pending. A lot of them actually are in litigation now, although not there's certainly also still pending investigations that are not yet in litigation. But just going through some of the bigger tech companies, starting with Apple. So there, as Edurne mentioned, there's some investigation, I guess, in Europe, but Apple has also faced litigation, actually brought by private actor, Epic, the games, the Fortnite company. And they challenged Apple's requirements around if you want to make apps available or services available to iPhone users, you have to go through the App Store. And if you use the App Store, you have to use Apple's payment system, and that's what they challenged. And Apple charges a 30% commission. So that was what that case was here in the Northern District of California. The judge disagreed with both parties' market definition, and sort of found something somewhere in the middle. Ultimately, found that Apple had significant market position, but was not proven to be a monopolist. Didn't find any federal antitrust violations. And so the App Store exclusivity and everything was upheld. The only thing that the judge did sort of rule as an antitrust violation, but only under California state antitrust law, because that has a broader spectrum. It sort of says anything that violates the spirit of the antitrust laws is a problem. And so California antitrust is comparatively plaintiff friendly. And so under that law, the judge did hold that the prohibitions against app developers steering consumers to alternate places to buy their apps or services was a violation, and had a remedy for that, enjoining Apple from doing that. Apple also faces another sort of similar app developer class action around these issues. So those are the main Apple cases, and that case is now on appeal in the Ninth Circuit, so one of the federal appeals courts in the country. For Facebook, probably have heard the FTC and certain state attorneys general brought cases against Facebook, challenging their acquisitions of Instagram and WhatsApp. That's now in litigation. Part of the case was also certain refusals to deal or terminations of API access for certain app developers to the extent that they had competing type apps. There, the FTC initially, their complaint got dismissed on market definition grounds, among others. And then they got to amend their complaint and file again. And that complaint was upheld by the FTC, but only was upheld by the district court for the FTC, but only to the extent it challenges Instagram and WhatsApp. The challenges of certain refusals to deal type conduct were again dismissed, and this time not with leave to amend. So those are out of the case. The state attorneys general lost their case entirely because they challenged they are subject to certain statute of limitation and latches requirements and couldn't overcome that. So they're appealing it now. So those are the main Facebook cases. So the FTC's case is proceeding to what's called discovery. That's a long phase. So we're a long ways off from resolution of that case. But the FTC ultimately cleared the first hump as to their challenges of the Instagram and WhatsApp transactions for now. That's going to be long running. Google, there's a Department of Justice case challenging Google's search distribution. So has to do with sort of placement of the search engine on certain OEMs, mobile devices, or default setting. That's the main challenge there. That case is in discovery, and I don't expect any decisions. I wouldn't expect any decisions in that case this year, but maybe next year. There are also state AG attorneys general who are challenging Google's ad tech business or certain practices in their advertising technology business. I won't say too much about it. I'm representing Google in that matter. But it has to do with various refusal to deal and product design, self-preferencing claims. Facebook is involved in some of those cases as well, because they also challenge a certain agreement around between the bidder auctioneer agreement. So those cases are pending alongside class actions, and they've been sort of consolidated. It's mostly the state of Texas, really, and a number of other Republican states, and then class actions around this. No decisions, but motions to dismiss are pending. So there could be a decision at some point this year around that. And then there's the state attorneys general who are challenging certain Google Play Store policies that has similarities to that Epic case against Apple. There's no decisions in that case yet either. I don't think there's going to be anything to expect this year. I'm not sure. So those are some of the other pending cases. And then there's Amazon faced a case by the the District of Columbia Attorney General, but that got dismissed. And beyond that, the FTC is investigating Amazon as well. It's a little murky as to what, but they're focused on their cloud business apparently. They may be looking at their acquisition of MGM and maybe other issues such as the one that Edurne focused on in self-preferencing and their marketplace business. So that's a quick overview of pending cases in the U.S., the major ones. There's also another case that's in healthcare tech. It's much less publicized. It's not a consumer tech case, but it's against it's about electronic prescribing against a company called SureScript by the FTC. I do think it will have very similar issues around two-sided market definition. So it's an interesting one to watch for that, because it will have similar issues as some of the big tech cases.
Okay, thank you, Daniel. Can say that you do have a lot of investigations, not necessarily the same theory of harm or the same problems that you face in Europe, but the tech companies are being investigated much more now than in the past, especially in the US. And Edurne, talking about the DMA now, we have recently seen that maybe we are reaching a consensus regarding the final terms of the DMA. So I would have 2 points to discuss with you. How do you think that the implementation is going to work? How effective do you think the implementation is going to be? A second, what's your view about the discussions around DMA, the most important topics that you'd like to highlight, and what do you think about the proposals that is related to the DMA?
That's a very relevant topic. I mean, as you all know, the DMA, this Digital Markets Act, which the European Union has finally agreed upon and adopted, has been a lengthy process, a rather innovative one, in a way at the same time a speedy one, if one thinks the time it has taken to really have a consensus within the European Union about sort of this ex-ante regulation, which is going to address the digital market, not with the traditional tools of competition law, but rather on a regulatory basis, establishing certain rules, and which is expected to enter into force in spring next year, and has been, and I can say that, revolutionary. Changing completely the approach to how these things should be addressed, with the idea also of having this ex-ante approach and not and avoiding the very, very lengthy competition cases which had often been at stake, taking sometimes as much as 10 years. So this ex-ante approach now is going to make sure that whenever we have certain players, which to some extent the ones now at stake already seem to have a name, which have, I would say, what they call a gatekeeper position. That is, a position where they control certain sufficiently relevant elements in the digital world, taking into consideration number of users, turnover figures. Those gatekeepers, those companies which, if we can name them, are Apple, Facebook, Amazon, Microsoft, Google, but also other names which are not yet, I think, necessarily, there's no consensus if they will fall within the categories, but there are already people like Netflix, Airbnb, Booking.com, Zoom, Oracle, or SAP. Those players will need to comply with certain requirements, very much related to data access, to grant other players access to certain elements which are considered key or fundamental in order for them to operate in equal terms, with a threat of very heavy fines, up to 10% of total turnover worldwide, with also a team at European level foreseen to enforce these measures. Very significant. We are talking about more than 150 officials within the European Union, which are going to be monitoring that. And also the idea that it's not only going to be the DMA, which is going to try to address these issues, but we will see in parallel running the enforcement of the DMA, but at the same time, that doesn't take away that the traditional enforcement tools, according to competition law, will also be able to continue. So we are going to have their sort of parallel track. And the big question is, how is this going to operate in practice? But well, the idea is that the Commission is trying to do everything possible on both fronts. And I hear, as I say, there are issues related to data, which is a key element, but also self-preferencing again, which needs to be avoided, and interoperability needs to be ensured. Undesirable apps need to be sort of easily removable, and there are a number of issues which are there in the text of the DMA. But as everybody says, the big question mark is how is that going to operate in practice, and what is going to be the reality? We all have heard about a lot of litigation being anticipated, so that whoever is being affected by this rule is not going to just take it for granted and abide by everything in a very humble way, but probably is going to engage lots of lawyers, economists, and people who are going to challenge whatever is going to be tried to be done in order to enforce these rules. So big question marks. I think interesting times. It's in itself already great and amazing that this has been passed. Now we will see how that works in practice.
Yeah, no, and when we read about news on these issues and how this agreement was constructed over the last years, I think it's quite interesting how the debate really was made inside the European Union as a whole, and how national countries and parties are seeing the DMA. So I think that there's a lot of things just going on there. We'll have more questions about this, but just to put the debate in an equal pace, let me just ask you, Daniel, and I think basically the discussion is a little bit different in US. I mean, the process is a little bit different from what we have in Europe. But we have seen a lot of different trends going on in US, and I think since the executive order from President Biden in the beginning of last year, we have seen a lot of changes going on in US, and also we have seen a lot of movements inside the Congress, and it's quite interesting to understand that this is like a bipartisan support for specific bills that are being discussed in the US. And we have seen bills, for example, the American Choice and Innovation Act. We have seen the Merger Filing Modernization Act. We have seen many different bills just going on in the United States before the Congress. And I mean, it is a discussion inside the Congress, and we never know how it's going to end. So in your perspective, first of all, what are the most important bills that are being discussed there? If you could name some of them, and what's the likelihood of those bills being passed in the next months or even years? How's the timing? How's the process? If you could just give us some perspective on all of this stuff, it would be nice.
Yeah, thanks for the question, Ricardo. It's there's a lot of activity in Congress. Antitrust hasn't been popular like this among politicians for a long time. We all seem to, or the politicians at least in Europe and the US, all seem very eager to create more work for lawyers than engineers, or maybe government engineers. So it'll be interesting if some of these bills, even if some of them pass, that, you know, certainly the Digital Markets Act seems destined to pass, and I think the U.S. bills are certainly not nearly as certain to pass. There are a lot of them, and in traditional fashion, usually always have a House bill and then a companion bill on the Senate side, and they then have they're sort of competing in some ways. They can be companion bills that can ultimately get consolidated, but there are often some differences, and I can talk about a few. So there are a lot. I mean, I think the American Choice and Innovation Act is, in terms of which are most important, I don't know. I mean, I think that one is definitely one of the leading acts. If we look at the ones that are focused in particular on digital platforms, there's they all have these wonderful long names, but the Open App Markets Act, that really goes to the Apple and Google Play type cases. And then, you know, different politicians come up with their own, and then they try to get sponsors. It's true that a number of them have both are sponsored or initiated by one side, and then have a few supporters from the other. So I would say, and a number of them maybe up this as soon as June. But whether they pass or not is still a question mark. I think the American Innovation Choice Online Act and then the Open App Markets Act are maybe more likely candidates, but there's still a lot of politics around it, notwithstanding them having some bipartisan support. I think it's some maybe bills proposed by Democrats that don't have a few Republican counterparts supporting it. But definitely not all the Republicans support it, and so it's a bit of a weird world where Democratic and Republican politicians who are mortal enemies on virtually everything else somehow have found common ground here. There's nothing you can't go wrong in bashing big tech companies these days, although they often have their own individual reasons for doing so that are very, very different. So we'll see. I mean, I think there's still, at least reportedly, the rumors are there's bargaining, right? One politician says, okay, well, I'll support your bill on this if you support mine on this one, or I'll only support this, but then you have to agree to this whole package of other bills that I'm proposing. And so it's that sort of horse trading that seems to be going on that makes it a little unclear as to whether and which ones are going to pass. I think one thing that's happening is Klobuchar has her more general antitrust bill that is not really only big tech related, but really is trying to overhaul the antitrust laws generally in very, very significant ways, including, you know, reducing a burden of proof on market power or dispensing with it altogether, overturning various Supreme Court cases on predatory pricing, refusal to deal, and two-sided platforms, creating presumptions against mergers above $5 billion. And I think that's one that she would love to bundle in with some of the big tech focused antitrust bills. But I think that's where it's much harder for her to get Republican support, because they are seemingly more comfortable focusing on a few companies than the entire economy. And so there's these politics going on. I think so it's a little unclear what's going to happen still as to whether these bills are going to pass, which ones, how they're going to pass, whether they still get amended. So it's hard to tell you what's going to happen. But some of these may come up for votes in June. So that's soon. And so we'll see what sort of bargains, if any, get struck to get some of this passed. And some of them are very modest. You mentioned the merger bill where the fees get increased and more fines need to be made. That's the least controversial. But and I think the other one to keep an eye on is American Innovation and Choice Online Act and the Apps Market Act, and then other similar acts. And so the American Innovation and Choice Online Act is focused on big tech platforms, has some similarities in some respects to the Digital Markets Act, but is not, the scope is not as broad as the Digital Market Act, but they have sort of covered platform as the definition with similar parameters to assess, like gatekeeper in the Digital Market Act, and then various prohibitions against self-preferencing and other sort of interoperability conduct. And the challenge there is that for some, they don't require, or there's no requirement to prove market power in these bills. And then for some, you don't even have to prove harm to competition. That's there are three types of conduct that are subject to proof of harm to competition, but the other 7 are not. And then the burden is on the defendants to prove that there was no harm to competition or some other pro-competitive justification. So they, create some significant changes to the antitrust laws and for very specific companies. And then you have these nuances. The House version of that lets private parties sue as well, and that's of course a big thing in the U.S. because they could go for treble. I don't know if they could get 3 full damage, so treble damages. That's a huge deterrent in addition to government enforcement. Whereas the Senate version of that bill doesn't have that and only lets the government enforcers go after it. And it, you hear sort of the major counsel in the committees who are behind these bills, and they're very much focusing on and referring to some of the conduct that's being challenged in some of these pending litigations as the reason to do this. So it's pretty clear what these bills are designed for. There's a lot to say because there's a ton of these bills, and I'm happy to address any one of them if you have questions, but it would take a good amount of time, and it's just unclear which ones are going to pass, if any, and in what form, because there could still be lots of changes to it as well, even if they do pass.
Yeah, very interesting, this bill, and very interesting the perspective that, as you mentioned, for different reasons, but there is some consensus among very historic Yemenis in the sense of way of thinking and principles that they defend. So yes, interesting to see, and interesting also about the results of all of this discussion. So we are following these discussions here in Brazil, and we are really curious to know what would be the outcome. Just before making another question to Edurne, there's a question here in the chat, and I think that it really talks with the question that we would make a little bit later. But I think that's useful to address it right now. Marcela Matiuso, she's asking about your last speech, Edurne. So she's saying, Edurne mentioned that the DMA is a revolutionary regulation. In what sense do you believe it's revolutionary? In terms of the tool itself, it looks like a fairly typical method of proposing excellent rules. Of course, it addressed a market that was up until now not regulated, but I would like to understand your view. Thank you in advance. I think she's basically questioning about what is exactly revolutionary in the DMA itself. It's the way it was done. It is the regulation of internet. It is what is the content that there is inside the DMA. I think she wants to understand a little bit better your view of this revolutionary side of the DMA.
Yeah, well, maybe I was a bit ambitious saying it was revolutionary. I mean, I think it's in itself the fact that we have seen many of these players, which each in their own niche play a very significant role and can be deemed dominant, and the European Commission, at least, and many of the other authorities, as we have just mentioned, trying to go after them, controlling and monitoring what they did and what they didn't do well. and try to impose conditions, to always try to, but they always had the feeling of being always too late. They were coming with certain conditions, then certain things were changed, and by the time that had been implemented, then the companies were already playing and operating somehow else, so that in a way, the authorities were always behind. So I think that's why for the first time there has been this decision to take an ex-ante approach where there is a presumption that because you are a certain player, you do have certain role in the market, in the digital market, and you have a certain turnover and a certain number of users. By definition, you need to do certain things in a certain way, so that the authority, the competition authority, doesn't need to prove anything anymore. They can still do that, if they decide to go that route, but otherwise there's already a presumption of things having or needing to be done in a certain way. And that is what I find is revolutionary, because I know we have a lot of regulation in certain areas, but not this way, not in relation to the digital market, and the sort of more modern type of dynamics which we have seen in these areas, and where the authority in Europe has decided to, let's do this completely different. Let's just set the rules in a certain way, and then all the companies are going to be sort of presumed to need to abide by them if there are certain objective elements which are fulfilled, and the obligations will just go along. And that takes away a lot of the burden which used to be on the competition authorities, which needed to monitor, to follow, to analyze, to prove that certain infringements had been at stake, and accept and evaluate commitments which were offered by the companies, which then maybe, if they were offered, were maybe not necessarily complied with, or even if they were, maybe, the commitment which had been offered had already been too old because things were working differently. So in that way, I find it's revolutionary or neat or innovative. I don't know how you want to call it, but it's a change of paradigm. So you're not going to go monitoring the specific behavior, but you're going to have this sort of ex-ante approach that you need to do certain things if you are having a certain role on the market.
Yeah, thank you. And I think this talks with the proposed question that we had thought before. I mean, we have seen the DMA, it provides certain products and services to be targeted by the regulation. It provides the gatekeeper, so the rules for finding a specific company as a gatekeeper. And it provides some sort of conducts that would be regulated in an ex-ante approach. And I think, considering everything that you have said until now, how will be this battle? I don't know if the battle is the best word, but how would be this relationship between ex-ante and ex-post analysis? I mean, if everything will be, or at least all of these conducts will be analyzed in an ex-ante regulation, in an ex-ante approach, is it the death of ex-post traditional analysis for these specific conducts? I mean, in relation to digital markets, or is there space for some sort of living of two regulations in the same moment, or at least in the same way?
You're right. I mean, one could question, if this ex-ante control works properly, as it is meant to be working, maybe there's no need for, in parallel, having an ordinary enforcement of competition law the way it had been working so far. That's still a very open question. The idea is that in principle, both things can operate in parallel, and you could very well have, the ex-ante rules, and if for whatever reason certain things escape the coverage of the DMA implications and ex-ante regulations, you could still have additional measures in the traditional way at hand. And actually, there has been also a recent court ruling of the European Court sort of establishing that those things are not necessarily incompatible, that there's no bis in idem, so they are addressing somehow different things, even if they can be linked. And the idea that everybody is arguing is that both things could still work together. But I agree with you, if the problems sort of disappear, because of the ex-ante rules and the consequences thereof, maybe there's no need for the traditional enforcement of the rules anymore.
What elements of the US regulatory proposals they are moving closer or further away from the European model? What do you think is the basic distinction between DMA and those bills that are being discussed in the US? How do you think that the American jurisdiction should address issues related to the need to build ex-ante regulation? So, and what kind of bills do you think should be approved? Not necessarily they are going to be approved, but should be approved in the near future. What's your opinion for that?
Thank you, Silvia. I just want to echo, I think Edurne is earlier, this is pretty revolutionary, all this stuff. If it comes to pass, DMA seems like a very, I don't follow the process carefully, but that seems like a done deal, more or less. In the US, it's still going to be seen. But basically, I mean, this is a plan to regulate the entire new economy, right? And ex ante. So that's that's pretty revolutionary in my view, because as Edurne pointed out, if you do this honestly, you can't just go over after 4 companies or 5 companies. You have to then sort of assess that for every sort of segment or new segment of the digital economy and figure out if there's a platform that's specialized in this or that. And so certainly see a lot of clients wonder, oh my, is this going to apply to me as well? And so that's ambitious. I mean, that's sort of the government taking over the economy and regulating it ex ante. And I agree with doing it. If it were to actually work, what's the point of antitrust anymore, other than for your cement bid rigging cartels or something like that? So it's pretty ambitious, and so I would say very revolutionary. I will not venture. I think, you know, I guess the people in Europe, although you can question how democratically, you know, how democratic that really is in Europe with the European Union, but they have chosen or close to, and so we'll see what happens. But it's very, very ambitious and revolutionary in my view. On the U.S. side, how does it compare to the Digital Markets Act? Well, I think there's less certainty about what's going to pass and what it's going to look like. I think if you take the entire amalgam of all these, because there's like 6, 7 or some of these bills pending in the US, if you took them all together, I think you get pretty close to what the DMA does. But if you look at it on an individual basis, I think the DMA, just by virtue of its length, it's way more, there's way more words in it than in the American Innovation and Online Choice Act, for example. But there are definitely similarities that, you know, I mentioned already, covered platform versus gatekeeper, about the factors that you look at to determine whether a company qualifies as a covered platform or a gatekeeper seem fairly similar. There's similar sort of rules against self-referencing. But I think there's more privacy rules, for example, in the DMA, privacy-oriented rules or data-oriented rules. So it's definitely more ambitious. But then there are bills in the U.S. that focus more on that. So if you take them all together, there's quite a lot of similarity. And generally speaking, Silvia, I would say the U.S. and Europe, if these bills actually pass in the U.S., are converging more on this than before. Europe, in some ways, is leading, as has been the case in a number of these things as of late. But they're catching up in the U.S. in terms of taking similar approaches, but with the major caveat that I'm not sure which of these bills are going to pass and what they're going to look like. So I think there's similarities between the amalgam of all the bills in the U.S. and the Digital Markets Act, but it's much more piecemeal in the U.S. So if only 1 or 2 pass, then it's less ambitious than the Digital Markets Act, I would say. That's at a high level. I hope that answers your question. I think it's all a terrible idea, frankly. But you know, if that happens in the democracy and bills pass, I guess that's the will of the people, sort of.
Okay, thank you. Yeah, we have to wait and see what's going to happen in Europe and then how it's going to be reflected in the US and which bills are going to be approved. So moving on, you have a question here from Paulo Oliveira. I think you all can read it from the Q&A bottom here. I'll try to read it, but probably it's easier for you. And I think it's addressed to Edurne, but of course, Daniel, feel free to comment as well. So regarding the DMA, several questions can be discussed regarding the regulatory initiative and its implementation process, given the chance of litigation. In a recent text of Chicago Booth Stigler Center's Pro Market, several scholars in the area point out measures such as the orchestration of an ecosystem of compliance and enforcement around the European Commission, enable learning by doing tools, establish global forums on the regulation of big techs, reduce the asymmetries of expertise between regulator and regulated in the area of technology, mainly from the creation of teams focused on the area, and etc. What other measures can be listed regarding the challenges of implementing the DMA specifically? I think here we have some challenges pointed out by the Stigler Center report, new report. And besides those ones, which one do you think can be a measure, an efficient measure for implementing the DMA?
I think that's a very interesting question. And I mean, I must say, it may be true that, you know, all this is very innovative, speculative. Nobody knows very well where we are going to end up and where this is going to take us. And as I mentioned earlier, and also Daniel mentioned, also don't know who is going to be covered by all this. So I think it's all a big question mark, I'm afraid. I mean, I don't have a clear answer to the question. I think even the officials, when you speak to them at the European Commission, I think nobody really knows exactly where this is going to end up, which, you know, is a bit scary, but at the same time is where we have. So I think it's going to be trying to do the best. And also, I mean, we have to be conscious and aware that the DMA, which we now have as almost finalized, it's also been the result of huge compromises, debates, with lots of input from various perspectives. A lot of, indeed, the data protection and the privacy and all that also being at stake. And also the European regulators have had to try to satisfy everybody and find sort of an equilibrium in many of things. So, I'm afraid I can't give much more clarity than, let's see how this works in practice. And I don't think anybody really knows where we're going to end up, I'm afraid.
Yeah. So I started my career in telecoms regulation at the Dutch Telecoms Regulatory Authority, which was a separate authority at the time. And then while I was there, it sort of got merged, or right after I left, it got merged into the Competition Authority as we know now. And some will say, oh, this is just like telecoms. We regulate. There's nothing new about this sort of approach. And it's true. In the U.S., you still have the FCC, right, regulating the telecom side. I don't think it's at all like that. I think, first of all, for telecoms at the time, there were basically in Europe, you had a maybe arguably a monopolist in each country, historically designated by the government, and you wanted to undo that. And there were major sort of literally physical infrastructural barriers to digging through streets, getting permits for that. And whereas in the digital economy, if anything has lowered barriers to entry, made it easy for new companies to enter, it's the internet and cloud services. And you see massive entry and new companies being super successful, TikTok, the Airbnbs of the world. And so I think there's major differences that justify one regulation, but not the other. I will also say, having worked at the Telecoms Regulatory Authority, I was relieved to get to the Competition Enforcement Agency and actually have some more professional approach to this, because it was just Wild West, like, oh, how does this work? They seem like they have significant market power. Let's just designate them and then force them to lease lines. It was a fun first experience as a lawyer coming out of law school, but it didn't inspire a whole lot of confidence in government, my experience at least. And that was in telecoms, where you actually had arguably a pretty good reason to want to break that up and open. And then I think the scope is different. I mean, this is literally attacking the entire digital economy, or attacking it, or at least trying to regulate it ex ante. So it's a massive undertaking, much broader than telecoms. So yeah, I don't know. It's going to be interesting to see. Yeah, maybe you could sort of see a similar approach where you have an agency or a unit within the competition agency that deals with this, but it's going to be a lot of work, and how that interacts and what the point of antitrust enforcement is if you're going to preemptively regulate everybody ex ante. I don't know. So just want to add on to Edurne's observation. This is hard to predict, but some people say, oh, there are parallels in the past and we've done this before, but I don't think the justification for this is at all the same as it was for that. And I think this is a much broader enterprise than any sector-specific regulation that we've seen in the past.
Fully agree, and I see there's an additional comment along those lines. That this is more ambitious than revolutionary. I think probably Felipe Late, who mentioned that, is absolutely right. Yeah, whether they have the tools, the means, the ability. I mean, it's all very much to be seen. And I think that the important thing is also they're going to need to choose their battles. I mean, they are not possibly going to be able to go after everybody or everything. So they will have to see how they prioritize. Yeah,
I mean, think about your taxes. I mean, this is going to be, if you want to do this properly, it's going to be huge resource suck. And then all of these bills, and these were all written by lawyers, of course, and we all love lawyers, but we know, if we're going to be honest, we know our shortcomings here. But you need actual technologists to do this properly, right? You need people like really good software engineers to, if you want to enforce this properly and do it. Are you going to pay them like the private market pays them, or what are you going to do? It's just otherwise you're just going to be in the same boat where lawyers who don't really know what they're talking about are setting rules, enforcing cases that have all kinds of unintended consequences. So yeah, good luck.
I can already tell you, for example, one of these comments which goes around in Brussels, which is, for example, concerning economists. All of this potentially targeted companies have been hiring left and right all the possible and imaginable economists, which could assist any complainants in any of these cases. So, the big question is, who is going to be assisting in some of these cases if you need an economic analysis to prove that there is some infringement? So just very sort of practical things like that are already sort of in everybody's mouth.
Yeah, well, here the U.S. solved that by at the agencies. The economists were really irrelevant in the views of the current enforcement officials at the agencies these days. So I guess that bodes well, because it's going to be just lawyers doing all of this in the future, it sounds like.
And Daniel, just to give you more information, I think that Felipe, who asked the question, is an official from CADE, and he was responsible until last week for technology lab at CADE. So the concern is probably the same you raised.
And he knows pretty well how difficult it is to apply the tools and to monitor and to do all of these regulation to be really applied in the market. So he has some grounds to speak on this behalf.
Yes, and besides all the challenges and the uncertainty, as an economist, I'm kind of glad to hear what you said, especially Edurne.
Yeah, I would say, to the extent, I don't know where Brazil is in all of this, but of course we're having this panel for a reason, and they're looking to Europe and the US and what is sensible to do. I would not suggest just adopt, definitely not the US, because there's some crazy politics behind all of this in the US, and so I think, just as Edurne pointed out, you got to really think about if you want to do something, what's reasonably feasible and actually effective and does good, and what can you reasonably do? And I just don't think that has sufficiently factored in Europe or in the US until now.
Yeah, we have 4 minutes left. So what I would propose here, I think we had many other questions here to make, and we knew that we wouldn't be able because of the time. I would make a question on remedies, but basically the question was how to apply structural remedies against behavioral remedies in this context. You can comment on this if you wanted, but I would like to hear in these 4 minutes, if you could have 2 minutes from Daniel and 2 minutes for Edurne, to hear your final remarks. I mean, and your final remarks in the sense of everything that we have discussed on the investigations, what is this training happening, the regulations. I think everything is interrelated. And also, what's your recommendation for Brazil from a practitioner view of all of these things happening? What you would suggest for us in Brazil to do? What is the correct path to follow on this regard? Should we go more for the investigations in the traditional antitrust? Should we go more for a regulation? What's our view on all of these issues just being discussed? So I don't know, maybe Daniel, you can start now, and Edurne, I think you can make the final comments.
Yeah, well, I would say for Brazil, if still things are up in the air, and I'm a strong believer in antitrust. I think all the antitrust cases that you see pending right now in the U.S. in tech show that there's a lot you can do with antitrust. It's very proactive, and there's a lot of change going on. So I would have quite a bit of faith in not abandon faith in antitrust as a tool that's flexible and can deal with a lot of things, especially because you're dealing with resource constraints. So you can't do everything. And so what is sensible to do? And I think antitrust gives you a lot of flexibility there. So I would be very cautious about just running after Europe and the US and creating all these regulations that literally regulate the entire digital economy, and would be a huge enterprise with lots of uncertainty and not necessarily good for your economy if you want to have business and invite business in. On ex ante, post, and behavioral remedies, all I just say in the US, the trend now is everybody hates behavioral remedies. I think in Europe, they're still much more open to that. But here, they even now, some of the, Cantor, the head of DOJ, is saying, I'd rather go to court than accept even a divestiture remedy in a merger if it's not really super solid. So that's it's very interesting if you contrast that with all the bills that are sort of ex ante, but behavioral remedy type bills in some ways. And so that would change as well. That's just quick observation. I know we have limited time, so I'll hand it over to Edurne.
No, I would definitely also not be in favor of adopting a sort of parallel to the DMA. I think it's an experiment. I would rather see how this operates and works in practice, and not really engage in something which is so unknown and where it's such a question mark what the result thereof will be. I mean, for me, the big question is, and we've heard that a lot and often in relation to the US, for example, going into sort of, a model of restructuring certain companies, going into a sort of AT&T type of baby bell type of move, and when I hear that, I find that so invasive, and that goes so far that the DMA looks even not such a bad solution. But I'm very curious if that will ever happen in the US, or if they will just keep in more the traditional way. But if that were to at some point happen, and we've heard that in several fora, that would be for me the big revolution as well. But and I would be interested in Daniel's view, but in any event, otherwise I would just wait and see.
Yeah, definitely wait and see. Because it's also unclear as to the US what's going to happen, and unclear in Europe as to how this DMA is going to work in practice. So I think waiting and seeing and letting everybody else make all the mistakes first, and then see what works well, what doesn't work well, is probably a good approach, is what I would say, while you still have antitrust to do a lot of things with. Some of these bills do contemplate actually requiring divestiture or prohibiting more acquisitions by tech companies. So there are several bills that have more or less sort of preemptive structural remedies, such as you just can't acquire anymore, or if you have this and that, you need to divest one or the other effectively, or you just can't favor. I mean, some of the self-favoring is going to be so hard to actually comply with that you're just better off not having both businesses. And again, then you're just turning companies into dumb pipes and utilities. Basically, what we're trying to do here is turning all the innovative companies into the Comcast cable companies and electricity utility companies that everybody so loves for their great service and innovation. So just another warning that I wait and see is definitely, I agree. That's what you want to do.
Well, I think that we have now reached our time here. I want to thanks to let you know that the discussion was great, and I think that we would be very happy to be here for a couple of hours, but unfortunately there is no more time. Thanks a lot, Ricardo and Silvia, for preparing this panel. I know that you and the other coordinators of the competition committee of IBRAC had prepared a list of more than a dozen of questions, but it was really challenging. And Daniel and Edurne, it was a great pleasure to have you, both of you here. I think that you provided us with what's the most updated information on what's happening abroad, and certainly it's very important for us as practitioners and our officials at the competition agents, the telecom agencies, to follow, because we are having the same discussions in our country. And we want to see you more in other IBRAC events. You are always invited, and we should think about having a podcast with the continuation of this conversation, because it was really good. Thanks a lot for everyone. Bruno, I know that you want to say goodbye, the official one.
Okay, thanks a lot. Thanks for the organization. Thanks for Edurne and Daniel. It was a great discussion. Thanks a lot for your reflections to us. And thanks to everyone. Have all a great weekend.